is the difference between living will and a trust? Do I need both?
Most people are familiar with a will. You've talked about it. You have an idea of what an executor might be. You've heard of a will. So, as you know, a will is a physical writing that manifests the wishes of someone at the time of their death. So, that's how they want their assets to be distributed. Now, there are also downsides to wills. Wills involve having to go to the court. It's a longer process and it takes money. So there's a 4% amount of your entire estate that's going to go into probating. So it can become very expensive. So one of the things that you can do to try to avoid that probate process, which has several reasons that you want to do that. One, there's an amount of time between the time of your death and the time for those assets being released to those loved ones. Two, the entire probate process and the amount of money that it costs. And three, because you really aren't sure about the time of your death and you'd like to be able to just go ahead and make things as easy as possible. So for those reasons, you might set up what's called a living trust. Now, what that is you actually take the assets that you own, such as a house, a car, a bank account, and you put those in a trust. So what a trust is it's a legal entity that is able to hold those assets for you. So you no longer physically own them. They're technically owned by the trust. However, during your lifetime, you're the sole beneficiary of that trust. So you can use those assets in any way that you would like. However, at the time of your death, you're able to name a single beneficiary or multiple beneficiaries for different assets. And so at the time of your death, if you died at exactly midnight, at midnight 01, those assets would transfer to those other family members. And they wouldn't have to worry about the process of getting a death certificate, going to the court, getting letters testamentary, going through the probate process, and it taking months and months and months to be able to get those assets. So typically what we would suggest is having both a living trust and a will. And the reason that we suggest that is you're able to use a living trust for assets that wouldn't go through the probate estate. But because it's hard to completely update, we have a plan where we'll update everything for you every 2 to 3 years or more often if you would like. Sometimes you'll miss an asset. So let's say you sold a car and bought a new one. So you hadn't put that new title in the trust. Then that particular asset would pass through the probate estate. And by having that will there, you're able to use the will for any assets that fall through the trust and end up coming into that probate estate. So the two of them working together are able to make sure that all of your assets go where you'd like for them to go for your wishes and that they benefit everybody. So for that reason, I wholeheartedly would suggest to anyone, no matter how young or old you are, doing that dual approach where you have both the will and you have that living trust.
A lot of people ask that, can I just have a will but not living trust, right? You just explained that the reason if you only have a will, you still have to go through probate. But if you have a will, you can avoid the probate. And of course, living trust can do much more than just avoid the probate.
So that extra layer of protection can be really important, especially if you have kids or loved ones who are in certain professions where they might be sued for malpractice. So for instance, one of the things they taught us in law school is if we are to get any inheritance, one of the best ways to be able to protect any of that money from the possibility of a legal malpractice judgment is to be able to put it in a health, education, maintenance, and support trust format so that we're able to keep any money that would be an inheritance from being included if there were a judgment to be passed against us. This is also important if you have a child that's a doctor or in any other profession where there could be a malpractice suit.
So living trust is not only can avoid the probate, but can also provide actual several layers protections for your loved ones when they inherited your assets.
Correct. And one of the other reasons that you might use a trust is if you had a child that was less savvy with money. One of the things that you can do is you can have a trust that under certain circumstances will give them the money instead of a lump sum that would usually happen with a will. So all these things are wonderful reasons that you might need a living trust or to create a trust situation, in addition to what everybody thinks of as the will as the document that you would use to be able to give out your stuff after death. And so one of the best ways for you to be able to prepare for which route is actually best for you is to go ahead and contact an attorney and have a candid conversation with the attorney about your assets and what your options are.